Right, hopefully you can see the slides now. Right, for the next 40 minutes or so, I'm going to be talking about role of expert witness in health and safety prosecutions. And as Shireen said, whilst a lot of my experience is related to construction issues, a lot of what I talk about will be applicable to other health and safety issues. It's just I'll obviously be using construction examples every so often to illustrate the issues. And what I'm looking to cover is, first of all, just touching on what an expert witness is, just so that we're all clear, and then looking at when they're needed, why they're needed, and what it is they actually do. And then to put it into context, I'll touch on 3 cases that you might have seen reported in the public domain and touch on the sorts of issues that would have been considered there. And then bring it all together and just give a few recommendations for some of the lessons that duty holders can learn from these cases, both in terms of preventing things happen and also just putting yourself in a better position if things do go wrong. So first of all, what is an expert witness? I think it's probably a term we've all heard of, but there's actually no definitive legal definition for it. And probably the best I've seen in terms of a definition is the one the Crown Prosecution Service uses, which defines an expert as a person whose experience is intended to be tendered before a court and who has relevant skill or knowledge achieved through research, experience, or professional application within a specific field sufficient to entitle them to give evidence of their opinion and upon which the court may require independent, impartial assistance. Quite a long sentence there, but one of the first things to know is an expert witness is actually distinct from a witness of fact. If something goes wrong on a construction site, you might expect, say, the site manager, various workers, all to provide evidence on the facts in terms of what they saw. The expert witness is actually allowed to provide opinion on those facts. And the other points that come from the definition is it's to give the court or tribunal an impartial opinion, i.e. you're there to be independent. And that impartial opinion is on matters that are within their expertise. So again, you should only really be providing opinion on areas that you know about. And one of the key points, expert witness isn't actually an advocate for their client's case. That's the barrister's job. The expert's duty is actually to the courts and to help them. So having looked at what is an expert, the next question is what actually qualifies me to act as an expert witness? Well, I'm a chartered engineer, fellow of the Institution of Civil Engineers and Institute of Structural Engineers, and over 30 years experience. My PhD was in the safety of existing structures. I did a fair amount of research and produced a lot of guidance on safety of existing structures, including being one of the authors of the Hong Kong Building Safety Inspection Scheme. When I was a director at BEng, I was the director responsible for our technical support framework with Health and Safety Executive, and as part of that, led about 40 odd projects for HSE on safety related topics. I've been advising HSE and duty holders on CDM issues since 2001. I led the independent evaluation of CDM 94 and CDM 2007. I've published a range of articles and reports on CDM, construction safety, structural safety. A few years ago, I was invited to join structural safety and the confidential reporting on structural safety panel, which is sponsored by HSE, the civils and the structures. And as part of that, we get a lot of anonymous reports that of near misses that we then analyse, produce reports on, produce newsletters on. And then finally, I've been instructed by prosecution and defence teams in over 30 cases in the last 12 years. And that last one is a bit circular in some ways, in that if you've acted as an expert witness before, then it qualifies you to act again. So I've done a fair range of sort of in-depth work over the years, got good insight into what happens in the construction industry. So that then qualifies me to provide opinion. And I've mentioned having been instructed by both defence and prosecution, and it's actually worth thinking about who can actually instruct experts. And for the defence side, it's typically the solicitor that will do the instructing and not the defendant. And the key reason for that is that being instructed by a solicitor allows legal privilege to be invoked if you're contemplating litigation. And that means that any discussions that I have with the legal team or the defendant, or the legal team have with the defendant, are actually protected by legal privilege and can't be disclosed to the prosecution, which is actually quite important. It means you can have fairly frank discussions without those being used against you. On the prosecution side, it's a combination of organisation. You can be instructed by solicitors who are working for the prosecution authority. Alternatively, you can be instructed directly by HSE, the Office of Rail and Road, or a local authority. And for manslaughter cases, you can be instructed by the Crown Prosecution Service. Now, in terms of what an expert witness does as part of their duties, there's typically 4 main tasks that you need to do. The first one is quite often the largest, it's actually reviewing the evidence. And this comes from a whole range of sources. And say for construction, it includes contracts, designs, risk assessment and method statements, correspondence. Some cases it might involve site visits or test data, plus a lot of witness statements and interviews. And that'll typically come as a sort of initial bundle, and then you tend to find that you get new evidence all the way through. And that's quite important to review that as well, because you might find that the new evidence actually changes your opinion on the way through as more becomes available. And this evidence, it can range, some cases, from a couple of 100 pages up to, I think the largest I've had so far has been 32 lever arch folders. So that's about 16,000 pages. At the moment, I've got one that's about 10,000 pages of PDF. So quite a lot to go through. And of course, you're expected to be able to talk reasonably fluently about the contents of the evidence when you're speaking with the lawyers. Then the second activity is to produce a report that addresses the solicitor's instructions and provide opinion on the evidence in plain English that can be understood by lay people, judge and jury. And use the word instructions. Actually, it's just questions that the solicitors will put to you that they want you to answer. And this can range often just from a simple open-ended question such as, did the principal contractor comply with their CDM duties, right through to, I've had 14 pages of multi-part questions that the lawyers wanted addressed. Once you've produced a report, if there's other experts, if other parties have used the experts, then one of the things you would be doing is meeting with them, having gone through their report, in order to establish the points of agreement and disagreement. And having discussed that, you'd then produce a short joint report with the other experts outlining the areas you do agree on, the areas you disagree on, and why you disagree. And the reason for doing this is to narrow down the issues so that then hopefully any subsequent trial will be shorter and cheaper because you're focusing on the areas of disagreement and not wasting time on area of agreement. And then the final one, if it does get to court, is the giving evidence in order to help inform the judge and jury. And that takes three forms. In the first instance, you have what's called examination in chief, and that's where the barrister from the organisation that's instructed you will ask you a series of questions, and they'll be based on a combination of what's in your report, plus you'd have been sitting through the previous weeks of evidence that's come up from witnesses in court. So you'd be asked about what's come from that evidence in the previous weeks as well. And then once that's finished, you end up with the cross-examination. And here, every other organisation or every other party's barristers then have a chance to question you on your report and the other evidence and challenge anything you might have said before. And it tends to be not the most pleasant of experience, the cross-examination, but an integral part of the English justice system. And then finally, the third part is what's known as re-examination. And this is where the barrister from the team that's instructed you will go back and pick up some of the loose ends that have arisen during the cross-examination and ask extra questions in order to clarify that. So having looked at sorts of things or the sorts of activities that are required, the next thing is what typically do the cases involve? And over the years, these are the sorts of issues I've been involved in. And I guess anyone who's familiar with construction won't be surprised at some of these, particularly the falls ones, which always tends to be largest source of fatalities and one of the biggest sources of major injuries in construction. And they can be through fragile roofs, from roofs, internally, externally, scaffolding, through materials, through openings, through ceilings. And then the other thing we unfortunately get in construction is collapses, ranging from sort of bridge beams, retaining walls, flooring, scaffolding, structures being demolished, right down to relatively minor structures like mantelpieces and retail barriers, which still unfortunately lead to fatalities. And then another issue that comes up fairly regularly is temporary works. And it tends to be people taking temporary works perhaps as an ad hoc activity, not quite taking it seriously enough. So it tends to be things like trench excavations, masonry retaining walls, not enough sheet piling, rebar cage collapses, scaffolding collapses. And then in addition, you do get a few other hazards coming up, things like off-site fire risk for timber frames, flue blockages, cable strikes, electrocutions, entanglements, manual handling. So actually it covers quite a range of topics, but what tends to underpin it is the CDM regulations that most of these organizations will have duties under. So that's always the sort of common thing. The next thing is why are experts witnessed? Expert witnesses needed, and it's something touched on in the previous few slides, really to provide opinion to help courts and tribunals understand complex issues to resolve a dispute. And I think the key thing there is that complex issues, if it was a straightforward case, they wouldn't need expert witnesses on there. But where there's some element of complexity in there that it's not obvious, then that's where experts are particularly needed. And it's also to ensure a just outcome. The English legal system is adversarial in nature, and if the other side's making a lot of points that you don't consider to be just, then having an expert on board in order to address those points and actually provide an independent, impartial overview of what the circumstances were and the constraints and the issues, then it can help people get a fairer trial. And there tend to be two main uses of expert witnesses. The civil cases, these tend to be personal injury, where people are looking for compensation after an accident. And then on the engineering side, it tends to be sort of defects, cracking, lacks of strength, lack of fit, or particularly at the moment, concerns over that cladding. And these are really, the expert there is to help settle disputes really over costs in these ones. And then the criminal cases, which is where most of my work is, that's where there's either an accident or exposure to material risk. And as you're probably aware, you don't necessarily have to have an accident or someone injured for it to end up in a prosecution. The Health and Safety at Work Act and other health and safety legislation is primarily aimed at whether there's an exposure to a material risk. That's where the breach comes. And your role there is to explain the risks faced, and then it's to help look in a fairly forensic way at what the defendant's duties were, how they fulfilled those, what the defendant's duties were, what that meant in terms of sort of practical issues, how they fulfilled those duties, and then looking at what the differences were between what they should have done and what they actually did, and then look at the significance of any differences, and were any differences actually contributing to the risk, or were they largely insignificant? And really, what is to put defendants' actions into perspective, given the constraints they faced. Some things may look fairly obvious at first glance, but once you actually look at the case and the constraints and limitations and what options were available, a different picture emerges. And that's perhaps where experts are needed in order to look behind what might at first glance be obvious. Then the next slide really covers when experts are needed. Traditionally, people might think about it as being experts are needed when you're going to trial. And yes, they are, but actually there's quite a lot of other stages where experts are required before it even gets to trial. And a lot of cases don't actually get to trial. Like going through in terms of a sort of scale of increasing serious, the first one is challenging a notice of contravention. This might be a relatively simple letter from HSE or another regulator, and the duty holder may want to challenge that because they don't think that what was said was reasonable. The next one is challenging an improvement or prohibition notice. And this has been made easier in recent years following the Chevron case. Organisations can now challenge on the basis of excuse me, any relevant information available, not just the information that was available to the inspector at the time of the incident. And that's quite important because it means that you can take a sort of a rounder view of what happened and put in an appeal. And the Chevron case that I mentioned, what happened there, it was an offshore platform in the North Sea. A HMC inspector went on board, looked at one of the floor plates and said, that's corroded, it's unsafe, someone can fall through it. he then hit it with a pickaxe, which punctured it, and pickaxe would puncture most things. The Chevron people, that's a bit unreasonable test. They had the floor plates tested, and it was found that they had more than adequate load carrying capacity. So they used those tests as part of their appeal. Obviously, that information wasn't available to the inspector at the time that he did the inspection, but the courts allowed it to be used because it gave a better picture of the risk on the platform. That ended up going through the appeal and then the Supreme Court. And now it means any duty holder can use any relevant information they've got. The next thing is helping assess a client's position after an incident. If something's gone wrong, then an organisation might well want to take a deep look at it to see where they stand in case there is potential for charges and prosecution at a later date. The next activity is helping the legal teams advise their client on how to plea. If an organisation is facing a prosecution, they've really got two choices, either guilty or not guilty plea. And quite often the expert's evidence and report is actually called for at that point, so that the legal teams can get a feel for whether there was a breach or whether the client had done all that was reasonably practicable. And if there was a breach, was it a particularly serious breach or not? And that will then help to make the decision of whether they plead guilty, get the 33% discount on the fine, and then mitigate when it goes to sentencing in order to highlight all the compliant and sort of good practice that the duty holder did. Or the other option is, if they feel that the charges perhaps aren't that significant, or their performance is actually a lot better than the charges might suggest, then it would be to plead guilty and go to trial. Then the next use is if there's it's in mitigating a guilty plea, and it might be that this comes up after the previous stage, or it might be that the organisation's already decided to plead guilty, but the prosecution is suggesting a relatively high level of culpability and harm, which implies quite a large fine. The organisation might think that doesn't reflect what actually happened, and so they might want an expert at that point in order to explore the evidence and see whether what the prosecution is suggesting is reasonable or not. The other option from when an organisation has pleaded guilty is what's known as a Newton hearing. And this is where the prosecution and defence don't agree on the facts. Effectively, the defendant thinks they've pleaded guilty to one thing and the prosecution thinks they're guilty of something else, in which case there will be an expert report and then a hearing where the facts, or it's really to establish what the facts are before the judge then makes a judgment on the sentencing. And then the final one is the one that we might traditionally think, that going to trial following a not guilty plea. So there's actually quite a few occasions when experts are required. And something that I've noticed in recent years is actually there's probably more of a demand for experts nowadays because the sentences are a lot more substantial. Now, back in, I think it was February 2016, new sentencing guidance was issued, and one of the objectives of that guidance was that sentences should be sufficiently substantial to have a real economic impact, which will bring home to both management and shareholders the need to comply with health and safety legislation. And within that, the judges will base their sentencing on a combination of culpability, which is essentially to what extent is the organisation to blame, the harm that people were exposed to, and the turnover, with larger companies effectively having larger fines. And a few years back, I did an analysis of the sentencing data in construction after the first year of the new guidelines. And what I found in comparing the first year of the new sentencing regime to the last year of the previous regime, the largest fine rose from 1 million to 2.6 million. And you now find medium-sized companies were getting fines that only large companies had got in the past, the many hundreds of thousands or even in millions. There's also a relatively low threshold for custodial sentences for individuals such as site managers and directors. And found in analysing the data that in the last year of the old regime, of those individuals found guilty, custodial sentences rewarded to 1 in 3. In the first year of the new system, around 1 in 2 of those found guilty got custodial sentences, so either immediate jail or suspended sentences. So it feels like a bit more of a hostile environment now, and I think organisations are more likely to challenge or fight any charges or allegations due to the potential severity of fines and sentences. Right, slight change of direction now. And what I'll touch on here is 3 cases that you might have seen reported in the media. They were all well reported at the time. And I shall bring them up in order to illustrate the sort of issues that an expert would be expected to address as part of those cases. And the first one was one of the first prosecutions of a designer following a fatal fall. It happened back in 2005 and sentenced in 2010. And what it was a new building, and there was a plant room on top of the roof. And that plant room had a ladder going up to it. And you can see the ladder in this picture taken from HSE's website. The ladder went up, there was a walkway along the plant room. That walkway was guarded. But as you can see at the bottom here, the footing of the ladder was only about 1 metre away from the parapet. The parapet had no guardrail on it. And what happened, the first week the building was open, there's a problem with the plant. Someone went up on the roof to have a look at it. They were coming down the ladder, and obviously you've got to come down backwards. If you got to the bottom, their foot would have gone backwards, would have probably then hit the foot against the parapet, perhaps off balanced, and then with no guardrails there, they fell over the edge 9 metres and unfortunately died. And when that was tried, the architects and the planning supervisor had 120,000 fine, the principal contractor 75,000 fine, and it's unusual for designer fines to be less than the principal contractor fines, which give you an indication of how seriously the judge took the designer's role. And the sorts of issues you'd be thinking about in a case like this is things like the changes to the location of the plant room. It's had several locations before it ended up there. Was the risk of the changes to the plant room location actually identified and assessed? What was the guidance and practice on guardrails at the time? What were the opportunities to spot the risks in design, in construction, in operation? What were the opportunities to control the access to the roof, or perhaps provide fall arrest systems? So you'd need to delve right back through the full life of the construction project in order to look at those sorts of issues. The next one is a large ground beam that was 23 meters long, 3 meters wide, 2 meters high. So pretty substantial, fairly heavily reinforced. And you can see from the top picture here, taken from HSE's press release, what the reinforcements looked like a day or two before the accident. You can see there's fairly congested reinforcement there. There was no diagonal bracing or Z-bars or tiebacks in order to provide stability to the reinforcement cage. And what happened, it needed 3 layers of 32 millimeter diameter bars installed on top. And as you can imagine, a 12 meter length of 32 millimeter bar is fairly heavy. And when you've got that being pulled across the reinforcement cage, of course, with nothing to prevent it from toppling, there was what's called a racking failure, and the cage toppled over, a bit like dominoes really, and it ended up in the position shown in the photo underneath. Unfortunately, there were 4 people working in the reinforcement cage at the time, and all were asphyxiated. Now, when that was tried, the client got 500,000 fine, the principal contractor a 200,000, and principal contractor's director got 7.5 months suspended jail sentence, plus 200 hours of community work. Because 2 of the contractor's directors died in the cage, it wasn't feasible to prosecute the contractor, so the charges were left on file. Thankfully, we don't get too many multi-fatalities in construction, but it's quite a serious incident. So the sorts of issues that you need to think about here are things like, obviously, the principal contractor needs to be heavily dependent on both specialist designers and specialist steel fixing contractors. What is the expectation of the designer to produce a buildable design and actually provide a design for the temporary stability of the reinforcement? What's the expectation of a contractor to identify the temporary stability issues and then perhaps liaise with the permanent works designer to address them? What's the expectation of the CDM coordinator? Should they have picked something up? And one thing, actually, as an aside, that has been done to address this, the Temporary Works Forum, we produced new guidance last month to address these sorts of issues in relation to temporary works and temporary stability of reinforcement cage. So that's one thing. A response has been made by industry to help stop these sorts of things happening again. And the third one is something that at first glance might look relatively straightforward. What this is a central London building that's been converted into an art gallery. And an art gallery tends to require large doors in order to get in the works of art. And you can see where the police yellow tent is. Just above that, you can see sort of beige coloured frame with black and green tape on it, and one next door with red tape, and one to the left, a smaller frame with black tape. Now, these are actually the door frames, And unfortunately, one day, 3 of them needed to be stored on the pavement overnight, and they were left propped up against the outside of the building at the sort of that angle you'd leave a ladder at. And everyone thought they'd been strapped to the building. Unfortunately, they hadn't been. And the next day, the frames fell onto a passerby, unfortunately killing her. And it was one of those, it doesn't actually take much to push a frame over, even as heavy as that. But equally, it doesn't take much to stop it. Just a simple ratchet strap would have actually stopped it falling. And this actually ended up with best part of a couple of months at the Old Bailey, with 7 organisations facing prosecution. The subcontractor ended up with a 250,000 fine. The subcontractor's site supervisor was found guilty of gross negligence manslaughter and ended up with 12 months in jail. The principal contractor's site manager was found not guilty of gross negligence manslaughter, but guilty to a Section 7 Health and Safety at Work Act and given a 6-month suspended jail sentence. The other 4 defendants were found not guilty. So this is, it looks relatively straightforward in terms of a frame being laid outside but not strapped, but actually the issues were a lot more complex than you might initially think, because it's central London, so you've got to look at the constraints of working in a central London location where there's limited access, limited chance to close off roads and pavements. There's other construction sites going on nearby. And then looking at issues of a possibility of internal storage, was it feasible? What other risk controls were possible given the location and type of work? And then the duties and responsibilities in relation to the individuals and the organisations, given the constraints and the options available to them. But actually, you find there's an awful lot of constraints on people when they're working on these sorts of sites. So a lot of these require a fair amount of, sort of in-depth assessment. One thing that struck me over recent years is, well, actually, are there lessons that come out of this sort of work that might be helpful for people, either for trying to prevent things going wrong or just to try and help so that organisations are better prepared should something go wrong? And next few slides are just a summary of some of the things that occurred to me. Well, one of the obvious ones, this was a point actually made by a judge in a talk I went to a few years ago. Written contemporary notes and documents provide better evidence than recollections. Again, I mean, a statement of the obvious, but really having emails, notes, letters, contracts, those sorts of things are much better than trying to rely on somebody in 5 years' time when it goes to court, remembering what happened. And it also avoids a lot of the issues that happen where one person said something, the other person said they didn't. I mean, once we've come across things like contractor saying, well, the designer said I didn't need to shore up the retaining wall. The designer saying, well, of course I wouldn't tell him that. And of course, as an expert, it means you end up doing almost 2 versions of your report. If this is what was said and that's fact, then this would be my opinion. If this is what was said, then this would be a different opinion. And it's really up to the courts to decide which version is fact. But having a sort of agreed note or email or something in writing would actually be a lot more useful. So in terms of those documents, just sort of simple things that site managers and others keep a day book with short notes of who said what to who, any significant decisions, why they were made. And this is something I remember back to when I was first going on site in the late 80s. We were always taught keep copious notes, and a lot of that is just for sort of normal commercial disputes as much as anything. Then if actions are noted, they need to, and then they need to be sort of tracked and closed out, because if something, a potential risk is spotted, you really need to take some action against it, because if it turns up you haven't done anything, then that looks a lot worse. And keeping records of what's covered in toolbox talks and inductions is quite useful as well, because quite often what's happened, something's gone wrong later in the day, and actually there was a toolbox talk on that very subject that morning, but of course nobody's got sort of bullet points or slides or anything like that to, as proof as to what was done in the toolbox talk or the induction. So just keeping simple notes along with a list of who attended is quite handy. And another, it's surprising what makes its way into court documentation, and certainly emails do. So just as what you know, don't say anything to anyone in an email you wouldn't feel happy on being examined on later in court, because that does paint a bad impression of somebody if they've been fairly impolite or offensive in an email and it's brought up in court. And then what I find is the principal contractor or main contractor is perhaps the organisation who is most frequently ends up with a allegation or a charge against them, and largely because they're in control of the site, they're the main point of contact. And looking at the role of principal contractor over the years, the CDM role really boils down to three key activities: selecting competent subcontractors, checking that the subcontractors, what they're proposing in their RAMs is safe, and then monitoring the contractor. And the first one, selecting competent contractors, and it's probably okay for larger principal contractors with formal procurement systems, but for the smaller ones without that, it needs to be obvious why the subcontractor you chose is competent to do the job. Because one of the first questions against you will be, why didn't you employ a competent subcontractor? But there might be plenty of good reasons. I mean, you might have a very good working relationship with them. You've used them many times in the past. They've proved to be competent. They've got an excellent track record. So that sort of thing needs to be obvious as to why they're chosen and why they're competent. And then the risk assessments and method statements, or RAMs, this gets undue attention if things go to court. There's an awful lot of focus on them, and checking and approving a subcontractor's RAMs helps to show that a principal contractor has discharged their CDM duties. Not doing so actually puts them in quite a difficult position. And the reason it does is because if there has been no check of the RAMs, it can be implied that the PC hasn't checked how the subcontractor plans to do the work, not sure what plant and equipment they can use, what people, what risk controls. And that's, a lot of that is what's expected of a principal contractor, so that they know what's being proposed and can comment on it. And I appreciate there isn't a legal requirement to have a RAMs checklist, but it's actually very useful if things go wrong, and it shows that the right checks have been done. Although even with them in place, we've had cases in the past where many hours have been spent on court discussing why a page is missing from a RAMs checklist because it covered a particular hazard. It doesn't necessarily mean it hasn't been checked. It's just unfortunate some of these things don't always get copied. But of course, a lot more gets made of them at a later date. And it's also important to ensure that the RAMs is communicated to the right people when the contractor is briefing it out. So if you can get the contractor to keep a list of or get people to sign it, then you know the system of work has actually been briefed out to the right person. Another one that comes up regularly is monitoring the subcontractor. Inevitably, when something goes wrong, it's in an area that's not been monitored. Because monitoring is not like supervision. Monitoring is spot checks to make sure that contractors are doing what they've said they were going to do. And what you typically expect is a mix of monitoring from principal contractor. So this would be things like the site manager, site supervisor, just as part of their walks around the site, picking things up. It might be visits from directors, it might be internal health and safety teams doing checks and audits, external health and safety teams. But that sort of mix and match approach is quite useful. It brings in several pairs of eyes at different times. And the other thing is making sure it's risk-based. If you've got something that's an obvious high risk, like say a lifting operation going on, then make sure you've got someone out monitoring that. And last slide now, just a few other useful lessons. Employers need to be able to demonstrate that health and safety is being treated the same as other business issues. And that's something that is actually mentioned in the guidance that goes with CDM, but something that also brought it out to me. I went to a talk that Judith Hackett did many years ago when she was still chair of HSE. And she said something along the lines of, many of you say health and safety is your #1 top priority. She said, we know it's not. We know you've got a business to run. We don't expect it to be your top priority. However, we do expect it to be one of your top priorities. And I thought that made quite an important point. And for larger organizations, you might be monitoring various key performance indicators for a particular site. And so make sure there's health and safety ones. Other ways of addressing it, just making sure in project meetings and minutes, health and safety is always on the agenda and minuted and documented. Also have it on agendas for board meetings and discussed and documented. It all shows that health and safety has been taken seriously. In learning the lessons from previous incidents, it's quite important to show that lessons were learned, actions were taken, particularly if a previous incident was actually very similar to the one that's ended up being prosecuted, because that makes life a bit difficult if an incident's already happened and nothing's been done about it. And then if you're a design and build contractor, take design as seriously as build, which perhaps might sound a little bit of a strange sort of comment, but I think what tends to happen a lot of in design and build work, a lot of the design work is actually subcontracted out or done by specialist contractors rather than the design and build contractor themselves. And you just need to be wary of the sorts of risks that might actually come through that aren't as obvious as perhaps some of the construction risks. And one that comes to mind is on timber framed buildings. Whilst timber buildings might be safe against fire when they're built and they've got all the fire protection in place, whilst they're being built, they're actually quite exposed and quite fire risk. And the fire risk needs to be addressed as part of the design. And one of the key issues is how close are you to an existing building? And how close you are will depend or dictate what class of timber needs to be used, because some form of timber construction are more fire retardant than others. So the closer you are to existing buildings, the more fire retardant the timber needs to be. And that's something for designers and supply chain to be considering. And when the timber turns up on site, it needs to be the right class. And it might not necessarily have been sort of as obvious to the contractor. So, you know, be aware of these things that are design risks. And the final point is focus on doing what's reasonably practicable. Now, that's what an employer is judged against. It's what is in a lot of health and safety legislation. And the prosecution has to prove beyond reasonable doubt that you didn't do what's reasonably practicable. And I think something to know is, you know, if an extra risk control would have cost a few £100, and you didn't do it, the prosecution is likely to claim you didn't do all that was reasonably practicable. Right, well, thanks for listening, and I'll stop sharing now, and I think it's Q&A time.